wife. But this particular special penal law already addresses the problem, and we say that this particular law is more comprehensive, and it addresses the problem head on. The law is not blind and deaf to the cries for justice of these abused women. The law has never turned its back. Rather, the Philippine jurisprudence is evolving and adopting laws to solve current problems. We argue that these laws are even more comprehensive to begin with. Marriage is a special contract. Second argument. Divorce is not necessary because it gives unbridled freedom on the spouses to assert and define the grounds to dissolve marriage. In Maynard versus Hill, every contract is founded on the agreement of the parties, but marriages are not a mere contract. It may not be modified, restricted, or enlarged entirely upon the consent of the parties. Once the relation is formed, the law steps in and holds the parties to various obligations and liabilities. Evidence. In the US, the court only approves 22% of the entire divorce cases filed. The couples whose cases were dismissed ended separating anyway. Why? Because there is the filing of indiscriminate cases that testifies that the remedy is being abused. Couples flock to one easy solution which allows them to terminate marriage. Yes, sir.
As early as 1917 and even during the Japanese occupation, absolute divorce was already allowed in the Philippines. Is it your position, and even under the family code, it is allowed under Article 26 in the case of an alien spouse obtaining a divorce, allowing him to remarry? Is it your position that prevailing Philippine culture or norm is not ready for that?
Yes, it is also my contention, and it will be discussed further by the practicality speaker why it's not practical to adopt divorce. Thank you.
Right. Gwen, 2 minutes to interpolate, JP.
Good evening, Mr. Speaker. By definition, annulment severs marital ties, correct?
Not necessarily.
Okay, but couples who were legally tied are no longer legally related, right?
Yes.
So does this not in effect violate constitutional provisions as well?
No, because the constitutional
Then you are
provision...
yes or no only, Mr. Speaker. Then you
The
are
answer
necessarily
cannot be answered
treating
by a
this as
simple
an
yes or
exception,
no.
correct? Yes or no, Mr. Speaker?
No.
Then if no, then this principle is based on the failure to comply with marital obligations, correct?
Not only marital
In our
obligations.
policy, we refer to the failure to comply with marital obligations, do we not?
Yes.
Hence, our policy is not unconstitutional as it is based on the same ground. Mr. Speaker, is it not a fact that in courtship, we put our best foot forward?
Yes.
Is it not a fact that there are unforeseeable problems that arise during the marriage?
Yes, but it does just justify divorce.
Thank you, Mr. Speaker. Mr. Speaker, there are conflicts peculiar to marriage, are there not?
Yes.
Like custody, financial matters, domicile,
Of course,
freedom.
I agree with
that. Yes. That these are areas of potential conflict even under the law, is it not?
Yes.
And a spouse may react adversely to these conflicts, Mr.
It
Speaker.
seems that you're sticking to your super prepared speeches. No.
Is it not a fact that these reactions can be severe in their effects, Mr. Speaker?
Of course, they can be severe, but it does
That
not
domestic
justify that divorce
violence,
not to be
lying,
adopted.
cheating, Mr. Speaker, may result from conflict, is it not?
Yes, which is addressed
That
by criminal
reactions
law.
may have manifested where is not the conflict, were it not for the conflict, Mr. Speaker.
Yes.
Thus, domestic violence, lying, cheating, etc. can only emerge during marriage. Thank you, Mr. Speaker.
All right, Cliff, you now have 4 minutes to argue the beneficiality of legalizing divorce.
Thank you. Greetings. First, two rebuttals. The opposition makes much ado about VAUC law. However, this is ineffective. I ask you, what happens after the spouses are freed from imprisonment? The abusive spouse returns to beat the victim spouse once again. How is that sufficiency of the law? It's clearly inefficient. Second, they make much ado about U.S. divorce. However, what we have to analyze is that U.S. states implement no-fault divorce. No-fault divorces meaning that there is no state intervention. Thus, these applications are inapplicable to our current setup because of state intervention. Now, moving on to my speech, to the Honorable Board of Judges. How does our policy on divorce vary from theirs? First, our policy on divorce differs because of the imposition of mandatory pre- and post-divorce counseling. Pre- and post-divorce counseling teaches communication, legal education, conflict resolution, and cooperation skills, and includes reconciliation and counseling options. This necessarily produces the following results. One, because of legal education, couples make informed decisions, and we avoid the absurd situation where couples unknowingly and unwittingly have made their children illegitimate, i.e. an annulment. Secondly, because of psychological counseling, parents are taught the proper coping mechanisms to deal with the procedures of divorce and are taught how to communicate with their children. Thus, we mitigate the necessary negative effects of separation. Thirdly, Your Honors, counseling extends post-divorce, allowing couples to resume a degree of normalcy in their lives. This is preferable than status quo, Your Honors, because in status quo, we have actual areas of operative separation, i.e. through legal separation, annulment, and declaration of nullity. However, these legal measures have inadequate safeguards. Where do you teach the children to live on with their lives from that? Yes, Your Honor.
Mr. Speaker, my question is divorce is the final answer to a domestic violence, especially that Philippines is a Catholic country?
Your Honor, at this point we say that yes, it is one of the best features that we have because when couples legally separate, we actually allow sever all ties so that the abusive spouse has no actual reason to go back to the victim's spouse. And this is something that is concretely lacking in VAUC and other existent laws that we have now. Clearly, this is better than what we have in status quo. Now, proceeding further, Your Honors, by recognizing marriage, we recognize both the legal and the psychological benefits and effects are the backlash of separation and allow state intervention to mitigate these consequences. In the declaration of nullity, the parties are legally justified to pretend that no marriage ever existed, to pretend that I don't have to deal with the backlash of having my child suffer from our separation. This is what we avoid with post-counseling because parties retain the bonds of kinship by being civil because that's what counseling teaches them, how to be civil with each other and how to continue to communicate with their children. That's what's lacking again in status quo. Proceeding to my second submission, Your Honors. Secondly, divorce has proven beneficial for gravely troubled marriages. Studies show that children whose parents divorced perform better academically than children from similarly troubled marriages whose parents went to the brink of marriage but remained. Yes?
Will the enactment of a divorce law affect a very strong marriage?
No, Your Honors, because the foundation of a marriage is built on presupposes that the parties do not beat each other up. However, so therefore, divorce will not affect happy and fulfilling marriages. However, if we refer to marriages which are already characterized by grave violence, these are the marriages that necessarily require the remedy of divorce. Therefore, divorce will not affect happy marriages. Divorce caters solely to those aggravated marriages, which we seek to
Please
address
finish
with
up,
law.
Cliff.
Lastly, Your Honors, we say that remarriage allows couples better financial stability and actually allows them a two-parent family structure as opposed to a solo-parent family structure. It's better to
Okay.
have two parents,
That's all the
child-rearing
time we
than
have
one.
for now, Cliff. Voltaire, 2 minutes to cross-examine Cliff.
Your proposal is rather exhaustive insofar as having a lot of options to solve the marital problems, right, Mr. Chair?
Yes.
Mr. Speaker, rather. Why is it then still necessary if we can solve those problems through the existing mechanisms that we have, because they're not so mutually exclusive in your proposal? Why can't we fully implement those mechanisms so that we can not reach that point wherein we have to sever the marriage?
With all due respect, Mr. Speaker, but I don't see counseling in any of the options in status quo.
Does it not exist and provided for by a lot of mechanisms? Assuming, for example, it's not provided, can the state have an incentive to make that part of the solution insofar as solving these problems?
Mr. Speaker, you're conceding that there is a flaw in our current laws, and that's what we have to remedy.
Yes, Mr. Chair. We concede that there is a problem. We concede that there is no perfect setup. But can't there be any other alternative than to sever the marriage?
There is none, because in divorce, we actually allow the families to continue with the bonds of family and kinship. Where
Mr.
is
Chair,
that in declaration?
Mr. Chair,
of
if that particular marriage is severed and you were not able to rehabilitate the other spouse who is abusive and he re-enters again into another relationship, will that not also become a cyclical scenario wherein that particular spouse can also abuse the other spouse.
And that's
you
the
severe.
problem in the constraint of VAUC law. You allow the spouse to be imprisoned, be freed, and then go back to beat up the
So
victim's
if that's the
spouse.
problem, then you can simply rehabilitate that person and ensure that he is fully rehabilitated and he understands the nature and circumstances of his marital obligation. Is that correct?
Mr. Speaker, that characterizes the cycle of violence. It's against the very nature of the spouses. They cannot be rehabilitated because of the very idea of the cycle of violence.
All right. Voltaire, 4 minutes to rebut Cliff and advance your argument.
Ladies and gentlemen, we concede that at some point, love can be sweeter the second time around. But this doesn't mean that we can have the right or the privilege to simply renege on our promises, especially when this promise is not only to another spouse, but also with respect to the state. That's why we concede, Your Honors and ladies and gentlemen, that there is some value in dissolving certain marriages, but this should only be the exception rather than the general rule. Because our present system recognizes that when the situation is already of that extent, that you have to sever the marriage due to psychological incapacity, then sever the marriage, ladies and gentlemen. As second speaker for the beneficiality, what will I be talking about? I'll discuss why divorce is not beneficial in better preserving and protecting the interests of our major stakeholders. I will nuance this first on the level of the state. Nuance on the idea that marriage, after all, is a special contract vested with public interest. Second is with respect to the couples and the family, the active players in the marriage and the formation of a family, the institution to which a social fabric is actually based upon. Let's proceed to the first level. The state through the government is a third party in every marriage. Marriage as a contract is a matter of privilege rather than a right. Thus, the requirements that are strict in its perfection, once entered into, it forms part of a social contract between the citizens and the state. You have the responsibility towards the state that the byproduct of the union, which is the family, is supposed to be an incremental element in the formation of a strong citizenry towards nation building. This particular wisdom is embedded in a lot of jurisprudence. For example, Manuel versus People, which it declared that marriage creates the most important relations in life as having to do with morals and civilization. That's why all decisions currently, when you talk of failed attempts to dissolve the marriage, is ruled in favor of the union because our laws and our society sees a value in maintaining that particular union. Yes?
Mr. Speaker, how you can expound that a marriage contract is not a mere agreement but beyond that?
Because, sir, it entails another party. It's not only the two spouses but also the state, because the state also regulates and limits the kind of exercise of privileges that are contained in that particular marriage or contract, sir. Thank you. Proceeding now to my argumentation, we believe that marriage is necessary for state preservation. It is more beneficial for us to stand with the valid principle of making the family as a social unit. In your particular model, when you allow divorce, you devalue marriage because it becomes a cop-out solution to the vaguely defined problems that you already provided. There are only, it's not even comprehensive, but it's only 3. It does not even include a lot of other grounds that can actually exist in an abusive marriage. It's an easy way out when all else fails. And we have to recognize, the state from the very beginning recognized that they are actually capable in complying with their marital obligations already. You disincentivize couples to avail of the plethora of options that we have in saving that particular marriage, such as VAUC, such as even counseling. If the problem is that we can't fix the husband, yes, Your Honor.
Considering that divorce among Filipino Muslims is allowed, doesn't the constitutional mandate of equal protection demand the same treatment
Sir,
for all Filipinos?
it should not, because there's a difference with the marriage within the Muslim laws, because it is something that is integrated in their culture and integrated within their person as Muslims. That's why equal protection applies to them if you are a Muslim, because it applies to all of them, but not necessarily to a Catholic or to other individuals who do not belong to that fold of faith. Yes, ma'am.
Are you saying that you think there's no discrimination when we allow Muslims to have divorce and non-Muslims not to have divorce?
There's no discrimination, ma'am.
All right, thank you, Voltaire. Cliff, 2 minutes to cross-examine Voltaire now.
Mr. Speaker, I'd appreciate a yes or no answer to this series of questions, please.
Okay.
So first question, negative effects arise from separation, do they not?
Yes.
Now, these negative effects extend to legal separation, annulment, and declaration of nullity, do they not?
Yes, it's not mutually exclusive.
Yes. These policies do not provide for mandatory counseling, do they? Not.
As of the moment, yes, but we can add.
They do not. Okay. So now, Mr. Speaker, counseling mitigates or eliminates negative effects, does it not?
It can, but it cannot eliminate the stigma of separation, Mr. Chair. Mr.
However,
Speaker.
it does mitigate effects, does it not?
We're not so sure up to what extent will it mitigate.
But that's a yes or no?
Yes, it can.
Okay, thank you. But the effect of possible mitigation is non-existent in status quo, correct?
It can be present if you avail of that particular
Yes or no,
option.
please? It's not present, is it not?
It is present, Mr. Chair.
Is there post-divorce counseling in status quo?
There can be counseling and there can be post-divorce
Yes or
counseling.
no?
Yes, it does exist.
In what provision? Wait. Is there post-divorce counseling and annulment? In post-counseling in annulment, Mr.
Sorry, can you
Speaker?
repeat that again?
Is there post-counseling and annulment, Mr. Speaker?
No.
Is there post-counseling in legal separation, Mr. Speaker?
No, it doesn't provide.
Is there
specifically in the law.
post-counseling and declaration of nullity, Mr. Speaker?
It doesn't provide
Then
in
it
the law.
doesn't exist. Now, Mr. Speaker, those studies you cited earlier are based on separation, correct?
No.
Oh, isn't divorce a mode of separation, Mr. Speaker?
Yes, it is a mode of separation.
Okay, so those studies are based on the U.S., are they not?
No, not entirely with the United
But
States of
your
America.
counsel cited U.S., not?
You cited, but I didn't. I made a
Alright.
different research.
Bridge it up, gentlemen. Renan, you now have 4 minutes to give your constructive speech on the practicability of legalizing divorce in the country.
Thank you. Why should we let couples stay together when each of them treats the other not as their better half, but their bitter half? To the point